feel like I'm on. Oh, okay. Okay, so that means.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Morning. Good morning. Our next case is State versus Chemuti, and we will hear from the appellant.
Good afternoon, Mr. Chief Justice, and may it please the court. Stephen Bader from Cranfield, Sumner, and Raleigh, here on behalf of the appellant, the town of Mooresville. This is a case about custodial law enforcement agency recordings, referred to in this court's precedent by the acronym CLEAR. This is referring to things like body camera footage, dash cam videos, and the like. The Iredell County District Court ruled that record custodians like the town can release CLEAR pursuant to a subpoena. That ruling clashes with the General Assembly's directive in North Carolina General Statute 132-1.4a, which says that requests for CLEAR should be directed to the Superior Court, which shall consider 8 factors that determine whether to release the material, and that material should only be released pursuant to a court order. The district court's ruling also misconstrues the powers and the rights available to litigants under Rule 45, and the town of Mooresville asked this court to reverse. I want to focus my comments here today on sort of 3 topics. The first topic being the CLEAR statute itself and the mandates that it provides. The second being Rule 45, the subpoena power provided under that, and the district court's rationale. And then the third are my friends' arguments in their briefing that the CLEAR statute works to somehow impede Ms. Chemuti's right to access CLEAR in this case. And I don't want to lose that thread in the argument here today, and I want to point that out right now. This is a case about process. It is not a case about whether Ms. Chemuti has the right to access this CLEAR. Our position remains if she follows the process, she may very well be entitled to it. The town of Mooresville has never objected to that. It's a case about process. So looking at General Statute 132-1.4a, first enacted in 2016, working through it, subsection B provides that CLEAR are not public records and they are not personnel records. Subsection G then goes on to say that records in the custody of a law enforcement agency shall only be released pursuant to court order. Subsection F and then subsection G provide 2 different paths for somebody to seek the release of CLEAR. Subsection F allows for a petition that can be filed either by somebody that's depicted in the CLEAR or by a custodian. And then subsection G would otherwise allow individuals to file an action to have the clear released. While there are some procedural differences between the two, as this court's recently recognized, at a high level in either proceeding, the Superior Court sets it for an expedited hearing, considers the 8 enumerated statutory factors, can review the recording in camera if needed, and then can ultimately issue an order releasing that clear, putting restrictions on who it can be released to and what it can be released for. That's the process that our General Assembly saw fit as far as how to deal with this emerging data and the issues that it comes with. North Carolina's approach to public records, just to touch on this briefly, goes back to 1935 when we first enacted our Public Records Act. And while things have certainly evolved over time, what the statutory scheme reflects is that there is a preference for broad access to public records, but some records are not accessible. Others can only be released under certain terms and conditions and to certain persons. This statute is consistent with that tradition. And back in 1999, this court in Vermani versus Presbyterian Health Services recognized that where the General Assembly has declared that records are not accessible to the public or that they are restricted in some fashion, that legislation would supersede any common law right of access. So this statute reflects a policy compromise. I cited a couple different articles in my brief, but I would, at argument here this morning, reference the article wrote by United States Judge Richard Myers when he was on faculty at the University of North Carolina. One of the things he pointed out in the article is that CLEAR it finds itself at the intersection of 10 different areas of law and policy, including, among other things, police administration, privacy laws, data, First and Fourth Amendment rights. And what our General Assembly said is, here's how we want CLEAR to be handled. We're going to come up with a uniform process. These requests go to the Superior Court. That's the court with jurisdiction to decide these issues. That court is going to consider 8 factors every time, and based on those 8 factors, the court can decide to release the footage with or without restrictions or not. And that is the uniform process that our General Assembly has preferred.
One thing I just want to clarify your position on, what happens if it's Brady material?
Couple things. First, I think that the statute itself sort of bakes that possibility right into it in subsection H, because it puts the onus on the custodian to disclose the recording to a district attorney for one of 4 different reasons, including for use in a district court criminal proceeding like this case. So our position would be, if it includes Brady material, those obligations would flow to the DA, who is given this material by statute. There is no record in this evidence or argument that Mooresville did not fulfill that obligation, and that would be how the General Assembly would account for that possibility, accepting that discovery is not available in a criminal district court proceeding. Just on that point, I would add that while that's been one of the arguments raised, there's not been any specific facts or evidence advanced to suggest that this footage that in question is in fact exculpatory. And as we've laid out in the briefing and continually taken a position throughout this case, Ms. Chemuti is free to seek this material via either a petition or an action if she chooses, presumably would receive it potentially with some restrictions, whether it's inculpatory or exculpatory. So I think the Brady consideration, number one, the General Assembly accounted for and what it directed custodians to do. Number one, I would say it's not really fully realized in this case, given the record before this court.
And I assume your position is, if your client had given it to a district attorney who's prosecuting a criminal case, and the district attorney concluded that it was Brady material, that the defendant would not be required to go to a Superior Court judge and get some sort of authorization that the Constitution would compel the prosecutor to provide that to the defendant in the criminal trial. Is that your position?
Yes, I mean, in some, we would expect that the district attorney would comply with its obligations.
A little more broadly, um, doesn't the presence of subsection H, or maybe it's subdivision H, uh, in the clear statute, doesn't that demonstrate that the legislature was doing what you're saying, which is it was creating a compromise statute to cover clear in all contexts, including the criminal justice context, including the context of a trial?
I think that's exactly right. I think that's exactly right.
So as I understand it, then subsection H doesn't require the district attorney to go to Superior Court. The law enforcement agency shall release to the district attorney, but not to defense counsel, even if it's for use in criminal proceedings in district court or in order to comply with discovery requirements in Superior Court.
Right. I mean, that's what subsection H says. That's the compromise that the General Assembly struck, correct? Turning to Rule 45, what Rule 45 says by its text is that a litigant in a case can serve a subpoena on a non-party, in this case the town, and that the non-party has the ability to object to that subpoena if the material sought is otherwise protected unless a waiver or an exception applies. That is exactly what the town did way back when in this case. It raised numerous different objections, including timing. But as to the other protected material, our position is that this material is clearly protected by statute, given the background that I've laid out and that we've discussed. And there is no exception in the statute that would allow a custodian to release the record via subpoena. In the briefing, I pointed out the 8 statutory factors set out in subsection G, and the third factor is whether the person requesting release is seeking to obtain evidence to determine legal issues in a current or potential court proceeding. I mean, in other words, are they looking to get materials through a subpoena? I mean, that's the third factor. There would be no reason for the General Assembly to mandate that the Superior Court consider that factor if a litigant to a proceeding could just issue a subpoena directly to the custodian. And just by way of example, and certainly not, I'm sure other examples exist, but when this court takes a look at 132-1.4, the section that immediately precedes the clear statute that talks about records held by law enforcement agencies, there's a provision within that statute for 911 calls. And what that provision says is that 911 calls are public records, the transcripts can be released, the audio recordings modified can also be released so long as they don't identify callers and victims of crimes. But importantly, the original 911 recording shall be provided under process to be used as evidence in any relevant civil or criminal proceeding. Again, at least indicating from the General Assembly's perspective that that would be an exception that would allow somebody to serve a subpoena and seek an original recording. No such provision is found in the clear statute or anything similar.
Just to make sure I understand, I think this is getting Justice Earle's question. So your position, your client is, if this is a Superior Court criminal trial where the rules of criminal procedure provide for discovery, and the criminal defendant said to the district attorney's office, here's my discovery that I'm requesting. The DA would then reach out to your client and say, they've asked for all the body cam footage. We'd send it up to us under H because it's been requested as part of the discovery. It goes to the district attorney and then they hand it over. No need for a court order there.
I think that's correct. The only caveat I would be under the impression that the district attorney would have it beforehand.
Right, they probably would have asked
either
for it anyway.
way,
Yes.
yes.
And so really what's going on in this case that makes it different is just the policy decision the legislature has made that you don't have discovery in district court. And so it's more complicated.
Potentially, although I would say that, again, to the General Assembly's decision here with the clear statute, it's not designed to be complicated in the sense that there's no fee for the petition. You do it on an AOC form. It's expedited. So it is another step, but it's not designed to be a burdensome, drawn-out process. It's designed to get the petitioner the information that they're requesting again, presuming that they're entitled to it and that the Superior Court, looking at those factors, would believe that it should be released. I just want to hit on, two sort of higher level points here, kind of building within the subpoena argument. The first is that this is not the only statute that our General Assembly has enacted that says that certain records held by a state or municipal agency can only be released pursuant to court order. I provided a list of other statutes in my brief. It was not designed to be exhaustive, and I'm certain it was not. But it does provide some other examples where the General Assembly has said, look, things like safe babies court records, juvenile records, certain records that are held by the Secretary of State regarding registration and lobbying activities, those records can only be released via court order. Those statutes have separate and different procedures, but all of those statutes, and any statute like it, could potentially be unsettled if this court were to say that Rule 45, in effect, bypasses a General Assembly's policy choice that a record held by a state or municipal actor can be subpoenaed. And that's really the real world consequence of this issue here before this court. I mean, the General Assembly says, we want uniformity. If our officers who are in the field, who are making these recordings, if these recordings are going to be disseminated, we want to make sure that those requests are going to the Superior Court, that that's the court with jurisdiction to do this. We want to make sure that every single one of those requests, these 8 factors are considered, including any others. That's the way that we promote accountability in policing, as well as the privacy interests at stake with these recordings. To simply do that by subpoena is inviting a mismatch of outcomes among different courts as to what could happen when this material is disseminated, with or without restrictions, and all kinds of mischief that could come into play. This was the General Assembly's policy choice to try and avoid that. The last argument, or the last topic here that I want to hit on is just some of my friends' arguments about a right to access. I have the Brady note down. I'm not going to go through it again. I believe that the Brady concerns are both accounted for in the statute and not necessarily presented here. There is an argument about compulsory process. I would argue that that is not really applicable here either. There would be nothing to prevent Ms. Chemuti from using the statute to get the material that she wants and then presenting it at her trial, assuming that she could otherwise get foundation authenticity and that the material would otherwise be admissible. But she is not, the statute does not impede her ability to do that, such that compulsory process rights are jeopardized. And then the last argument that she raised really gets to the courts, or the district court rather, is inherent authority. But court's inherent authority is limited by actions taken by the General Assembly. This court recognized that, excuse me, in State versus Gravatt back in 1990, and that would apply here as well. If the court doesn't have any questions, I don't want to repeat myself or belabor the point. We believe that the statute is clear. We believe that the district court misapplied it and that it misapplied Rule 45. This court should reverse and hold that requests for clear need to be done via the statute and not by subpoena. With that, I reserve the remainder of my time. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning, your esteemed justices. May it please the court, I'm Jennifer Chandler. Co-counsel is Andrew Banzoff. We represent the appellee in this matter, Ms. Chemuti. I plan to cover the basis of the statute, which is the 132-1.4a. I'm going to discuss the framework. I'm going to also discuss the implementation and the consequences of the implementation if this statute was to be used and required to be used by criminal defendants and their attorneys in district court. This case is about justice. It's about seeking justice. And how do we do that except to seek the truth? That was when the judge in district court ordered the motion, or the town of Mooresville and the Mooresville Police Department to release what they're calling clear. That was an order, a court order. That is what it says is required under this statute, is court order. The only time that it mentions superior is when you're utilizing and requesting under this statute. And
You would agree, wouldn't you, that if there was a criminal case in Superior Court and the defendant went to a district court judge, got an order entered that said judgment of acquittal, that we would say, well, that judge has no power to enter that order, so it's meaningless. And I understand your friend to be saying the same thing here. No offense to district court judges, but only a Superior Court judge can enter the order here.
I disagree, because the intentions, looking at the actual legislative history of this statute, when you look at it, it was included with a bill that had to do with transparency of law enforcement. It had to do with providing giglio information. It had to do with decertification of officers and having a database. This wasn't about creating a universal, I shouldn't say that, but it's not about creating one process for all requests of clear. It is about the request that you could not get at the time this was enacted. That is what this is about. The only court that had jurisdiction was the one that wrote the order, and that was the district court. The criminal matter was in that court, and 7A 272 provides they have original and exclusive jurisdiction. And it's appropriate, as the trier of fact in district court, that they would be the gatekeeper. And that's what the judge did. And so it was an appropriate order to seek justice. The issues that were presented by, I'm sorry.
If,
Yes, Justice.
if the legislature didn't intend for this to be a comprehensive regulation of access to clear, then why do we have H?
I can speak to that. And it actually brings up another topic that's very important today. This is not about Brady. This isn't about discovery. This is about district court. And what was written and brilliant about the writing of 15A, 801, and 802, and then you look at the parallelism of 15A, 901 through 903. What is the difference? The difference is the burden is on the court under 15A, 801, and 802 to subpoena. We subpoena the evidence. It's on the court. It's on the attorneys. And that's what we were doing. But look at 901 through 903, and it's all about discovery. But the clear difference between evidence and discovery is only the line of possession. Who possesses it? The DA. So when evidence is evidence, it's just evidence. But it could be the same evidence, but be discovery, because it's in the possession of the DA. So that is why the 901 and 903 are written as they are, to limit the jurisdiction to Superior Court under that, and then require the DA the duty, because then they do have the duty, because they do have the discovery, and they do have the requirements.
But isn't the implication that, doesn't H imply that if it weren't there, the statute would prevent the disclosure or the release of this of clear to the district attorney unless the district attorney went through the process.
That's the reason it's written in there, is that if you look at H and you break it down, what it says is it can be released for the purpose of discovery, which would be only Superior Court. But then it has another section which says number 3, and it's talking about criminal proceedings and criminal prosecution, and they put district court there. It was clearly intended to allow, if they want the release, for them to get it without this process. But it also, by that distinction alone, makes clear that that was intended to be discovery for Superior and then a criminal prosecution under district. So that you have both instances. You have the fact that they have it as evidence if they want to use it in the prosecution in district court. And then you have the fact they use the word discovery when they say to follow discovery procedures because that's Superior. What's more important and speaks loudly here is the words that aren't written. Many times you learn more from what is not written and when there is silence. There's nothing in this statute that says anything about criminal defendants or about subpoenas. This statute was intended to create more releases, broaden releases for people who couldn't subpoena. Why can't they subpoena? There's not a case. You have to have, under the rules of 45, you have to have a case. You have to have a number. You have to have the jurisdiction. These cases and the substance of the clear that is intended under the statute is the recordings of when individuals are injured, seriously bodily injury, or a death by law enforcement.
Here's the a problem that I have with your reasoning. I think you said in response to my question that without H, the implication would be that the DA would have to go through this process. Mm-hmm. And you're right. Criminal defendants aren't mentioned. Mm-hmm. In other words, they don't have a carve out. So doesn't that work against you?
As I read it, it does not. As I read it, it doesn't apply. It doesn't apply to criminal defendants because it's not that it was overlooked. It was never overlooked by the General Assembly. Their intention, and maybe they shouldn't have written it the way they did, but their intention is very clear by what they list as what clear it and what it is containing in those videos is what this is about and what the releases are about is only that subject. And the only time, and I believe opposing counsel brought it up, the only time that we could ever apply for this would be under subsection G. And subsection G, those 8 factors, when you read them, it's clear that it was intended for whether or not a video of substance, which is listed under all the other factors, if it should be considered under those 8 factors by a Superior Court judge when releasing. Those 8 factors, it doesn't make sense to apply that to a criminal proceeding in district court. We're overlooking what's really, really important here, and that is the actual implementation of this.
So can I understand your argument then if there was a family law proceeding in district court and there was some dispute and they wanted to know whether a parent was in a particular place and realized there may have been a law enforcement officer on routine patrol whose body camera footage may have captured one of the parents, could they just use Rule 45, get the district court order, and never go to Superior Court?
I'm only focused on 15A and 801 and 802. So I really, the court order aspect of it, the subpoena, the way that we're supposed to get evidence can only be answered under the criminal proceedings.
But why is that? Because under the rules of civil procedure, you also have the same power that the court presiding can issue a subpoena, compel someone to produce documents. Why would it be different in civil than in criminal?
I don't know civil, and I'll be honest, and that was part of the problem. And this is why I had to issue filing, because Rowan County requires them. And before you know it, my case is 6 months. District court has been delayed for 6 months because I can't get the filing right in Superior on this. Then I go back and we have to move it because the notice wasn't provided right. And then we have to move it again in Superior because I have a conflict. And then, so I have 2 different dates that are ongoing trying to get a video, and it's delaying district court and Superior Court.
Well, I guess the reason I was asking
Yeah.
though is if there's no principled reason
Mhm.
to treat the civil and the criminal differently, you could see the problem here, which is if you could also just get a subpoena approved by a district court judge in a civil proceeding, then you have completely cut the heart out of this statute, because district court judges then can just routinely order municipalities to turn, local law enforcement to turn over these records.
I apologize. I would argue first, I can't argue the civil part. I don't want to go to that because we're really focused on the 15A, 801, and 802. What I will say is I know kind of the issue is, well, suddenly all these people are going to go get subpoenas. And it's going to have to be that the subpoena and the subpoena power is there. We're not going to have a floodgate of people suddenly filing subpoenas, because this rule has been there before the enactment of this in 2016. It's not going to cause a floodgate. It's actually going to direct your releases where they need to go in the right jurisdiction. Because without that, we're going to have jurisdiction over here with Superior Court deciding what videos to release. We're going to have District Court criminal. It's delayed because we don't have that video yet. And then you don't, and I get what, it is true that would have to be, though, I'm not knowing civil, that there would have to be a procedure to follow under the statute. And this statute, and my argument would be that this statute was not intended for people who actually had subpoena power. That's not the intention of this statute. The reading of it is clear in the sense of it's about videos that people, and if you go to the authorized person, and that aspect of it is a personal representative of an individual who's seriously injured or basically killed by law enforcement. Those are the videos we're talking about. That's the clear we're talking about. And the G subsection that they turn to, which is the only one that we would be able to file under a petition, which the petition currently on AOC, we can't file. It says under subsection F only on the form 270. It does not allow us to actually file. And that being said, that alone is problematic, but more importantly, reading the full statute, you don't see the defendant, you don't see 15A, but if you go back to 132 and dash 1.4, it's pretty clear that 15A is supposed to apply. So this wasn't an oversight that 15A was to apply, is my argument. And that the district court had jurisdiction, and if we implement this in the way that they are asking, we're going to have judges that are required in Superior Court to watch 10 to 20 hours of videos on each case. We're talking about DWIs where multiple officers show up. We have to watch all the videos, and that's going to hold up Superior Court. And that being said, I would just say the implementation alone would be highly problematic and cause a serious frustration to the processes of our courts. Thank you. I turn it over to Andrew Banzoff. Thank you.
May it please the court, I'm going to talk a little bit about compulsory process and the inherent authority of the trial court to order production of materials for the trial. Our position is that this statute is a supplemental procedure to the traditional use of subpoenas that's authorized both by statute but really is authorized by Article 1, Section 23 of the North Carolina Constitution and the Sixth Amendment to the U.S. Constitution. This is those statutory, those constitutional provisions embody the old common law that even predates those about the right of defendants, the right of litigants in cases to subpoena materials to the trial. That's what this is about. This is not about getting the videos in discovery or Brady. This is about being able, the ability of a litigant to obtain materials to bring in for their trial in their case. Justice Deese, you asked the question, would a family law litigant be able to do that? I would argue yes, because there's no meaningful distinction in my mind between a litigant in a civil matter and a litigant in the criminal case. Their ability to issue a subpoena. I agree with you that Rule 45 applies equally in both ways. The question, the way that you framed the question was, does it gut the statute? I would argue it doesn't gut the statute, because what we're talking about is really two different things. We're talking about cases where there's a pending action in court. We've got a judge presiding. And then we have situations where there is no pending action and there is a need to obtain the videos for a variety of reasons. And that's what this statute is intended to cover. It is not intended to cover the situations where there's a case pending. And the reason for that is because of the traditional role of subpoenas and compulsory process. As I noted in the brief, we have a long tradition in North Carolina of not reading statutes to create a constitutional problem, the old constitutional avoidance principle. The problem with the town's position is that they're inviting this court to rewrite the statute in such a way that it creates a constitutional problem, because it necessarily indicates that litigants, particularly criminal defendants in this particular case, cannot subpoena materials to the trial. And that absolutely creates a problem, a constitutional problem with both Article 1, Section 23 of the North Carolina Constitution and the Sixth Amendment. The right to subpoena materials to the trial, as I noted in the brief, goes back to Aaron Burr in this country and Thomas Jefferson when he was the president. In that case, the president's materials were subpoenaed, and Chief Justice Marshall allowed that and said that's perfectly within the bounds of the Sixth Amendment. So,
what do you think is the purpose, the broad purpose of this statute, particularly in the sense that it was put within Chapter 132 Public Records, but it says pretty much at the outset, these recordings are not public records and they're not personnel records?
Again, I think the broad purpose of this statute is to provide a mechanism for the disclosure or release of videos in circumstances where there is not a pending action. In other words, there's not a judge to otherwise go to get an order for release.
Whose interests are being protected by this statute?
Well, I would argue it protects a number of interests, right? It protects the persons who are depicted in the videos, both the officers that are involved, but also the persons who are witnesses and or suspects, etc. So it protects broadly from release to the public generally, but that's not what we're talking about, broad release to the public. We're talking about release to a trial court, right, no, for the purposes of trial.
But what is to limit the use of those materials? I mean, once they get in the hands outside the law enforcement agency, the custodian, what limits their use at all?
Certainly, the trial courts have the absolute authority to limit how those can be disclosed. If there's concerns by the state or concerns by law enforcement about disclosure of those outside of the trial, then certainly the court has the inherent authority to say, you can't post this on the internet. But again, we're not talking about, giving a copy of this to the litigants personally. We're talking about producing it at the trial in that limited capacity.
Which is a public setting, as we can look around this room and see. Our courts are open.
Certainly, but
you lose any confidentiality once the material is produced.
But again, I don't think that's really an issue, because if the petition, this is really about the procedure for how these videos get to the court, not whether or not playing them in court is, somehow releases confidentiality.
Why not allow the Superior Court, which has experience in these matters, to review the request and make the determination what, if anything, can be released and what the parameters of that release would be?
I'm not aware of any case that's ever been decided in the U.S. Supreme Court or in this court which somehow burdens the compulsory process right in that manner, that says you have to jump through these hoops before you can subpoena materials to your trial. If such a case exists, I'd be happy to see it, but I don't believe such a case exists. I believe that the U.S. Supreme Court cases have uniformly held that there's an absolute right to, not a qualified right, but an absolute right to subpoena materials to be produced at the trial. And I recognize that this statute has some intended purposes to limit the production of videos generally to the public, but I would argue that the way that we avoid a constitutional problem here is by acknowledging the traditional method of producing evidence at trial.
If you're right about that, what is, in your view, what does G3 do? So that's the standard the Superior Court is supposed to consider that says the person requesting release is seeking to obtain the evidence to determine a legal issue in a current or potential court proceeding. Because if you needed it in that circumstance, aren't you always going to have Rule 45 subpoena power? Either whether it's civil or criminal.
Well, we might be reading too much into the word current. I mean, that in a sense, the entirety of the town's argument rests on that one word. Does it necessarily mean that an action has actually been filed? I think it's intended to be a broad statement that say it might be potential litigation. Maybe you filed the complaint, but you haven't gotten in civil case and you haven't yet gotten to the discovery provisions. But again, I don't think it's a limiting word. I think it's an expansive word and intended to be an expansive situation, expansive language to encompass a number of situations. But again, I would submit that that really doesn't have any impact on an actual pending action where you have a judge who has the authority, as they did in this case, to order the production of this and to limit it in whatever way that the litigants asked to have it limited in terms of disclosure. But I don't know that that disclosure limiting is not necessarily that big of an issue in my mind when you're talking about producing it at the trial to be introduced as evidence.
Right. I mean, isn't it true in civil and criminal contexts that courts have the power to issue protective orders with all sorts of provisions about how the material can be used, even, what happens to it at the close of the legal proceedings, that courts inherently have that authority to issue protective orders?
Absolutely, and certainly that happens even in cases, in Superior Court and felony cases where there's videos. I've certainly been a part of cases where judges have said, you get this copy of this, but these are the limitations that we're putting on how you can disseminate that. You can show it to your client, but you can't give them a copy. You can, any number of ways in which the court can do that. But the court always has the inherent authority to regulate that, regulate the manner of how those materials are dealt with.
I'm struggling a little bit to wrap my brain around what I think you've argued, which is that the statute wasn't meant to apply to cases that are already in existence or actions that are already in existence. So we've got this language that Justice Steets pointed out in G3, current or potential court proceeding, and you're telling us current there doesn't mean current. It means potential, but the statute says current or potential.
What I'm suggesting is that the word current can mean a lot of things. It's a broad word, and I think it was intended to be a broad word to cover a wide variety of circumstances.
I think it means presently in existence.
But I would also submit that it's not a limitation. It's not an exclusivity provision. It doesn't say this is the only way that this material can be released. It's one of the factors to be considered if a petition is filed. And I think another important thing to remember is when we're talking about compulsory process, we're talking about compelling the production. The town says, well, Ms. Chemuti can always file a petition. It's true, she could file a petition and request release. But she can't compel the release. She can't compel the disclosure of that through the petition process. Only through the subpoena process and compulsory process can you compel the production of those videos. A Superior Court judge could decide, no, we're not going to allow you to have those videos if they look at the factors. And
Well, and that's where it seemed to me how you fit all this together, because I can imagine a criminal defendant in that context following the proper procedure and going to Superior Court and filing the petition and requesting this, and if explaining I need this in my criminal trial, and a Superior Court judge said no, you might have an as-applied constitutional challenge that, you know, this violates the right to compulsory process. You need this information as part of your criminal trial. But for us to just say we're going to ignore sort of what it seems to be the General Assembly's decision about how the procedure works in every case because of that potential risk in that one circumstance doesn't make a lot of sense to me. I mean, wouldn't we just let that happen on an as-applied basis if it ever happened?
I would just disagree. I don't think it's a good judicial policy to set up further constitutional challenges. I think if we're here to resolve this issue, hopefully we resolve it all together at one time rather than setting up piecemeal litigation where we have, you know, as applied challenges down the road. I think a better path forward would be to say this is a supplemental statute, not a statute that supplants the traditional understanding of subpoenas and compulsory process.
Do you think a defendant in criminal superior court would have a right to subpoena pursuant to Rule 45 the regular records of law enforcement agency separate and apart from discovery proceedings?
Can you kind of give me an idea of what records you're thinking about? Because I'm not sure that I understand.
Well, the case file that has been turned over to the district attorney, do you think a defendant would have the right to subpoena that information separate and apart from the discovery proceeding?
Certainly. Now, you know, whether a judge allows that, I think if the motion to quash is produced is a separate matter. And again, that's the other part of this that's important, I think. We had a gatekeeping function here already in this case, right? There was a motion to quash, it was denied, and the trial judge allowed, ordered the production at the trial. So the gatekeeping function that's envisioned in the petition procedure happened here. The town says, well, only a Superior Court judge can do that. I would argue that the statute says court order. It doesn't say Superior Court order. The literal wording of that sentence says court order. There was a court order here.
My basic problem with your position is that this really has the look of a statute that was intended to be comprehensive. It has express references to criminal proceedings, including proceedings in district court. It talks about current court proceedings. And what you're suggesting, as has been pointed out, would be a huge exception to that. And I would just expect, if the General Assembly meant there to be a gigantic exception to what appears to be comprehensive, that it would have addressed that in the statute.
Well, I'm going to turn that around on you, Justice Allen, and say this court has repeatedly said that if we're going to abridge a traditional common law right, that that statute that does that has to say that clearly and unambiguously. So the fact that this statute doesn't clearly say subpoena, Rule 45, Sixth Amendment, Article 1, Section 23, is indicative, and in fact, under this court's precedence, would not be a proper basis to overrule the existence, the completely existing scheme that's out there. So I think I see the donut the opposite way, in that because we don't even talk about those things, and I see I'm about out of time. I might just have a moment to continue my response.
Thank you, counsel. I believe your time's expired.
Thank you.
Rebuttal.
Thank you, Mr. Chief Justice. The town of Mooresville would ask this court to reverse the district court's order because it clashes with General Statute 132-1.4a and it misapplies subpoena power under Rule 45. I want to be helpful in answering any questions that the court has, but if the court doesn't have any additional questions, I would rest on the earlier arguments advanced.
Thank you, counsel.
Thank you.
Ayes.